Hello, everyone. I am thrilled to be joined over the airwaves today by two lawyers from the Belgian firm, the well-known Belgian firm, Van Bael and Bellis, partner Catherine Longeval, associate Malik Aouadi, who in the run-up to this year's Global Class Action Symposium in Madrid have been kind enough to join us to talk about the collective action landscape in Belgium. So one thing that surprised me, and you actually let me know this, Malik, when you emailed me the other day, is that Belgium has had a collective actions mechanism since 2014, one of the earliest in not just the EU, but the whole of the continent of Europe, and 6 years before the Representative Actions Directive. So here's a dual question. Given that Belgium was so far ahead of the class actions game by 6 years before the directive, first of all, can you update us on what the current situation is now? But why then did other jurisdictions that maybe came to the party a little later, how are they now outpacing Belgium when it comes to collective proceedings?
I'll take this one. Thank you very much. So indeed, until 2014, there was nothing in the Belgian legal framework to allow for class actions, American style, in Belgium. And then in 2014, I think we were one of the first to adopt a law that allowed for class actions in Belgium. And that was then further tweaked. The scope was enlarged on two separate occasions. And first time in 2018. Until 2018, only consumer claims could be brought. But in 2018, the law was adapted to also make it possible for SMEs, small and medium-sized enterprises, to bring class actions. And then second big change in 2024, when Belgium transposed the Representative Actions Directive, the RAD, into Belgian law, which brought further changes. Why has there not been much of an uptake, at least until 2024 in Belgium? What we saw was that only about a dozen cases were brought until 2024, and the majority of those were brought by the same claimant, which is a consumer interest association called Test en Co, Test Achat. They were the claimant in the vast majority of the cases that were brought. Since 2024, with the transposition of the RAD, we have seen actually several new cases being brought now by foreign group representatives. We'll come back to that later, which is a new development in Belgium, because now you can have cross-border qualified entities bringing claims in other countries, and some foreign entities have definitely seized upon that opportunity to bring claims in Belgium. But even so, the number of cases have been rarer, few and far between in Belgium, and I think that there's four main reasons for that. First one, the procedure in Belgium, like in many other cases, countries, I think, is quite heavy, burdensome, 4 phases: admissibility, negotiation, merits, and then enforcement, if the court decides that part or all of the claim of the claimant is well-founded. Second reason is that class action can only be brought by a qualified group representative, so that already excludes a lot of potential claimants. Third reason, punitive damages are not allowed under Belgian law. And the fourth, I think, one of the main reasons is that in Belgium we have a generalized system of opt-in. Unlike, for example, the Netherlands or Portugal, where you have a generalized opt-out system, it's no wonder why many, many claimants are flocking to those two jurisdictions because of the opt-out system.
What's your personal views of sort of opt-in versus opt-out against the backdrop? But when you have a claim that's worth a lot of money, but each individual component is quite small, somebody's overcharged something and everybody's entitled to 30 euros back. Obviously, on an opt-in basis, a lot of people aren't going to bother. And yet, on an opt-out basis, people are in anywhere. And at the end of the day, you go through proceedings that could take years and you end up with 25 euros. So both systems have those flaws. You obviously work, you yourselves, you work cross-border, including in the UK, where there's both systems really. What's your personal view of the merits and drawbacks of each way of doing things?
Maybe you want to start with that one?
Well, I think you have to see it against the backdrop of the actual intention of the legislator. Like Cathy said, in the past 10 years, there's been only a few class actions, and that was also due to how burdensome the process was. And one of the reasons why it was so burdensome is that during the admissibility phase, parties had actually to agree or to convince the judge of the system they want to adopt. So obviously, most of the time, claimants would like to have opt-out, whereas defendants would prefer opt-in. And that is one of the changes that was brought in the latest reform of the law, which generalized the default opt-in. But there's still possibility of opt-out if the parties agree. So the Belgian legislator still left this latitude of choice between parties, because in some instances, you can find that opt-out is a better fit. If, for example, there are less people that may be concerned, or they want to expedite the action, opt-out might even be also favorable to the defendant itself. Another thing was that because of this generalized opt-in, there's now also a late opt-in for the consumers. Before the reform in 2024, the consumers had to opt-in at the beginning of the 4 phases procedure, which meant that many of the consumers were reluctant because they didn't know if even the action would be deemed not only admissible, but also if he would have merits. With the latest reform, now consumers can opt in at the end of the procedures. So at that time where they already know that the defendant is liable and for how much.
That's really, really interesting.
I may add, we are very much so far a firm that represents defendants in class actions, so we're not a claimant firm. So from our point of view and the point of view of our clients, I think they very much favor, obviously, opt-in as a system. The only advantage I can see to opt out is where, for example, you have a case where one flight or a couple of flights were delayed, and the airline refuses to grant compensation, and then you've got maybe a couple of hundred passengers who claim compensation from the airline. There, indeed, the defendant knows it's not going to lead to a humongous group of affected consumers if it agrees to opt out. But that's, of course, only a limited number of cases, especially these days where you've got claims against tech companies for alleged data privacy violations and such. They're not going to be very keen on opt-out. And as Malik was saying, we have the option under Belgian law of the parties agreeing on opt-out, but frankly, unless in a very few specific cases, you're never going to have an agreement between the parties on opt-out.
Sure. Now, as you mentioned, as you mentioned, you work on the defence side. Now, if you're working on the defence side for usually large companies, collective actions can't really proceed against large companies without some sort of third-party litigation funding. So first of all, as another 2-part question, can you explain what the legislation and regulation is in Belgium about third-party funding? And how do you feel about it?
I can take this one, indeed. So before talking about third-party funding, maybe we can also address simply the funding. Under Belgian law, there's no specific rules for the funding of collective actions. And actually, this is often considered as one of the main weaknesses of the class action regime, and the reason why so few actions have been initiated in the past. Well, of course, class actions are expensive. Punitive damages are prohibited, and also success fees, and all of the costs have to be advanced by the class representative, of course. A couple of years ago, Testasha, the leading consumer association that Cathy referred to a bit earlier, reported that each case cost them €150,000 per case, mostly in attorney's fees. And of course, these had to be fully advanced by the claim representative. And this is risky because this class representative may not be able to recover these costs. If the court, for example, decides that the case is not admissible, but also if it lacks merit. So it's a very, very risky gamble to take for class representatives. And then naturally comes the question of third-party funding. Neither the Belgian law, neither does the Belgian law or the RAD, the Representative Action Directive, prohibit such third-party funding. However, both regimes requires that measures are taken to prevent conflicts of interest, and some transparency requirements are met. Under Belgian law, if there is any third-party funding, then it has to be transparent. The claimant has to identify the third-party funder, but also how much he gave. What we've seen, Catherine and I, in recent developments was that a few claimants are trying to explore, let's say, innovative funding structures, such as by, for example, issuing litigation certificates, which promise some kind of return on investments on these litigations. And in our view, such financially driven model appear complex to reconcile with the ideological plaintiff type of action that Belgium had in mind, rather than these profit-driven vehicles.
Indeed.
So
One of the criteria in Belgium to be a qualified group representative is that you have to be not-for-profit. So the moment that there's a sign of you offering a return on investment to investors, that already starts to reek of, a profit objective. Secondly, you also have to show as a group representative that you're independent. So if you have these funders, who of course want a return on their investments, the question is, how independent are you as a class representative when you are deciding on procedural strategy, and whether to claim this or claim that, or whether to how to define the group and so on? If you are actually being dependent or discussing this with your funder, where does the independence condition fit in? So it's a very, very tricky, delicate balance to strike for a claimant.
So is there a situation where, because I wanted to talk to you about what qualifies you to be a representative entity, and what might make you disqualified from being a representative entity.
Yeah.
Now you mentioned if you're making money out of it, but what other criteria are there?
Right. So in Belgium, a class action can only be brought by a qualified representative whose statutory purpose, is directly related to the subject matter of the collective action. And we have two types of group representatives who can bring actions. On the one hand, consumer group representatives, and on the other hand, SME group representatives. And the conditions to be able to qualify are very similar for the two categories. So I'm just going to give the general conditions. You have to submit yourself to an accreditation process with the competent minister in the country where you are established as a claimant. And you have to prove at least 12 months of effective public activity in the field of protecting consumers or SMEs in the field in which you're bringing your class action. It can be GDPR, it can be a consumer protection, it can be a variety of areas. You also have to show, as I already said, a not-for-profit objective, which can be tricky, as we just discussed, especially when third-party funding comes in.
Yeah.
And also something that we already touched upon, independence and transparency of your governance and your funding. What's important as well is that a class action can be brought in Belgium by a group representative who has been accredited in another jurisdiction in the EU. And lastly, and this is what we're seeing in Belgium, in fact, we are seeing since the RAD was transposed into Belgian law in 2024, a small slew of class actions being brought by foreign qualified entities who've been qualified in another country in the EU and are now rolling out their claims across the EU, including in Belgium. Lastly, even if you have not been accredited by a minister, for example, you're a Belgian group representative who hasn't obtained qualification by the Belgian minister yet, you can bring a class action in Belgium and ask for an ad hoc accreditation by the court before which you brought the class action. But you can only do that at national level. So concretely, if you're a Dutch group representative, you're bringing a claim in Belgium, you can't ask the Belgian court to give you ad hoc approval. You can only do that as a Dutch group representative in a Dutch class action.
Sure, that's interesting. I'm well aware we're running out of our time here, but one thing, I know you haven't got a great deal of data to go on, but there's a lot going on globally in the collective proceedings universe. Things that even 5 years ago we wouldn't have talked about, crypto and blockchain. Big tech we've had for years, but they seem to be getting more and more pervasive into everybody's lives. So if you could get out your crystal ball and we were having this conversation in 5 years' time, what do you guess would be, putting on your defense hat, the most vulnerable sectors within your jurisdiction to be on the receiving end of class actions?
Maybe you want to do the first one, and I'll do this next.
Sure, of course.
Malik.
Well, you obviously have the very classic consumer products and competition law. If you take a look at the numbers, they still make the majority, a bit more than 50% of all their collective actions. And it's also likely to be the primary area of exposure in Belgium as well.
Yeah, for example, the Apple Store case is a classic, of course, of that type of class action. Then there's two more that we think, well, maybe three actually, when I think about it now. There's another one that just popped into my head. So this, the second one after the one that Malik mentioned is GDPR. Data privacy claims, I think, are going to continue to bring in a lot of class action work across the EU. In Belgium, it's not a coincidence, I think, that at least 3 class actions have been brought since the first position of the RAD in Belgium in 2024. And the 3 that we have knowledge of, for example, against Meta and against X, all concern, among other things, data privacy claims. The next one I think that we really have to look out for, which is going to bring in, I think, a lot more class action work, is the EU Product Liability Directive, started in 2024. Still needs to be transposed in quite a few EU member states, but there the definition of product has been enlarged to also include AI and software and so on. There's an eased burden of proof on the claimant and so on. I think it's a given that there's going to be class actions on product liability more often in the future. And then what I just thought about also is the forever chemicals. There's more and more legislation now, and also I think actions being taken by national and local governments against polluters, where these kinds of chemicals have been found in the groundwater, in the soil and so on. I think that consumers who've been affected by those PFAS chemicals are also going to start bringing class actions in Belgium and elsewhere against the polluters or the alleged polluters in that respect.
Yeah, I mean, with PFAS, I think we've all seen it's gone from quite a sort of small conversation among the legal and scientific community to something that is now in the public domain and is becoming a huge environmental concern. So I think that's not just going to happen in Belgium. I think that's going to be quite huge globally, from what I understand. Finally, what advice do you give your clients operating in Belgium to prepare for this brave new world of collective actions?
Well, we've seen with everything that we've discussed that the recent reform made it a broader, more accessible framework in Belgium. So we believe that there's going to be an uptake in Belgium, which means that companies should take this as a real operational risk that requires some concrete preparedness. The first step, obviously, is going to be to map the exposure, to conduct a systematic assessment of the product, the services, their commercial practices against the expanded list of infringements under the material scope of class action, which we know now Belgium refers to all 66 legal instruments referred to in Annex 1 of the directive. Second, and we've touched upon a bit on this, is focus on high-risk areas. Unfair contract terms, misleading commercial practices are the most common ground for collective action in Belgium. Ensure that general terms and conditions, pricing mechanism, marketing materials comply with consumer laws, but also, especially in the technology sphere and with the wide array of texts that have been published in the recent years, you could also focus on these because it's not only about the classic GDPR anymore, but you also have the DSA, the DMA, and the AI Act. Another worthwhile step also would be to monitor the claimant ecosystem. Most of the time, there are going to be NGOs which need to publicize their activities. So if you are aware of the developments, you could maybe see trends or patterns, both domestic and cross-border now, because you can see that a qualified entity recognized as cross-border in Portugal could also initiate one in Belgium. So pay attention to public campaigns and media coverage. And finally, if you are caught in the clutches of a class action, it's important to build a cross-border strategy. It is not unlikely, to say the least, that the claimant may initiate action in foreign jurisdiction also, and it would be very important to stay coherent amongst all of these jurisdictions.
This is a fantastic way to conclude this. Catherine and Malik, you have been fantastic. Thank you so much for taking the time out to talk to me. And I hope that one day soon we'll be able to see each other in person. Thank you so much.
Pleasure was ours.
Thanks a lot, Robert.
Thank you very much.